Hi, Michael. How are you?
Great, Maya. How are you doing?
I'm fine, thank you. Very happy to see you on this lovely day where the weather is really nice.
It's great to be here. Thanks for having me on.
Yes, and I wanted to talk to you today about a recent article that was published that you wrote that's very interesting because it actually encapsulates the frustrations that especially defense lawyers deal with. But before we dive into that article, I just wanted you to introduce yourself. I know many of us know you because not just as a criminal defense lawyer, but you're actually very active online. A lot of people follow you on social media, but still, if you can introduce yourself and tell us where people can find you online because you're very active.
For sure. I'm trying to be less active online. I don't think I've posted anything on Twitter for a while. Trying to remove myself from some toxic spaces, but I do still
Mhm.
post stuff that I write and links to everything that I do there and on other social media platforms. But yeah, so I'm a criminal defense lawyer. I'm a certified criminal law specialist. So I only do criminal defense law. And shockingly, maybe not shockingly, by looking at me, I've been doing it for 20 years. I had a bunch more hair when I started and a lot less gray hair. So I've been doing it for a while and in the trenches as a trial lawyer. I don't really do appeals or things like that, but just do some serious trial work. And then in my spare time, I like to complain about stuff. So I've got a column in Canadian Lawyer, where a couple times a month I sort of have an opinion piece come out, and I write in other publications as well, like the Globe and Mail, Star, National Post, places like that. And for about 10 years, I co-hosted with first one of our colleagues, Leo Rusomano, and then my spouse, Emily Tamman, a podcast called The Docket. I think we got to well over 100 episodes, but we're in a bit of a hiatus now, just because we're so
Yeah.
busy running around court and filling out forms that we don't have time to do all that other work. So yeah, that sort of describes who I am and what I do. I appear in Parliament a lot, so I talk to a lot of parliamentarians about new laws and things like that. And I try to, broaden sort of my advocacy, not just for my clients inside the courtroom, but for, other causes I believe in outside the courtroom too.
Well, and this article that we're going to be talking about actually is more geared towards lawyers and criminal defense lawyers because it really expresses the frustration that we deal with right now. And it is the title is Hurry Up and Wait. Um, it's not the exact quote, but that's mainly the idea in this article. And I want you to talk a little bit about this article for those who haven't read it, Michael, and then tell us why you wrote this.
Yeah, so I mean, I do write for criminal defense lawyers and other people who know the system, but I really try to be accessible as well because, I think that a lot of people don't really understand what it's like to be a lawyer, to be in a busy court system, and to be a defense lawyer. As defense lawyers, we deal with a ton of burdens. We see, the federal government download a lot of costs and administrative burdens to the provinces, who then download those costs and administrative burdens to local jurisdictions. And ultimately, criminal defense lawyers are at the bottom. So at the end of the day, each new law, each new procedure, it's really, the private criminal defense bar that ends up bearing the brunt of that. We are the sort of lubrication that keeps the wheels of justice in motion. And at the same time that we have all these new procedures and red tape and bureaucracy, and burdens downloaded onto us, we're having our defense bar gutted. A lot of senior defense lawyers and a lot of junior defense lawyers are leaving private practice, hired by the Crown's office, by other government agencies, or just leaving law
Yeah.
altogether, because we're overworked and we're generally undersupported. At the same time that we're
And
asked to do
underfunded.
exactly, at the same time we're asked to do more, we have provincial governments, cutting legal aid funding and other supports that we rely on. And so we don't end up doing less. We just end up doing more for less, which
Yeah.
makes sort of all of these burdens, extra aggravating.
And in this article in particular, you talk about I mean, what we see right now is that there's a lot of pressure, especially on defense lawyers, to move matters forward, especially in the intake stage where we're always asked to have a CPT right away, schedule a JPT even if disclosure is not fully ready or we are still waiting for important disclosure, not just, like for photos or something that we can wait for. There's always this pressure on us. It's either that or you waive 11B, and then once we get to the actual trial date, we usually find that there are multiple other matters that are also booked for the same time in the same courtroom, and we can't proceed, or there are, for various other reasons, things don't work out. And this is really a frustration that we all deal with. And you talk about this in the article. So I wanted you to elaborate more on that, Michael.
Yeah, so and I mean, I think it's important to distinguish between sort of institutions and systems and people. I'm often very critical of the police or the judiciary sometimes, certainly crown attorneys, and it's not being critical of the people. So when I
Yeah,
say what I'm about to say, I fully recognize that there are some crowns, and most crowns probably care about getting matters done quickly. And the courts, I think, in general, judges care about timely justice and making sure that people don't wait in custody and that matters are heard in a timely manner. But having said that, the system doesn't care about providing a timely trial. They just care about avoiding charges being stayed. They just don't want charges thrown out of court. After Jordan, we have sort of very arbitrary and rigid timelines put on our
yeah,
trials, 18 months
yeah.
and 30 months.
Hmm.
And those numbers literally were plucked out of thin air by Justice Moldaver
Hmm.
in a hearing that wasn't even really focused on the numerical amount. And we've seen it in previous generations of lawyers, like in the 80s and 90s. We dealt with ask off in like tens of thousands of matters being thrown out of court, and really the new Jordan case hasn't resulted in that level of charges being stayed. But what it has resulted is sort of a moral panic by courts and by crown attorneys because they don't want to be on the receiving end of a stay. And so the whole system is designed to avoid that stay, avoid having those
Yeah.
charges thrown out of court.
Hmm.
And so, if 18 months is the limit, that's the goal. Like that's you're offered trial dates right before that. You're not offered, trial dates in the next week or two or month, even if you're prepared. And so it's just about it's a shell game to avoid looking responsible for delay on the part of the courts and the crown attorneys. And, that I think paints with a really broad brush. Sometimes cases should be done in a week or two. If you have a fail to appear trial where the
Yeah.
whole case is admitted and your client is just going to get up there and testify for 2 minutes that I forgot about my court date, why are they waiting 18 months for that trial? And sometimes you've got cases that can take a long time to resolve. Perhaps there needs to be like a lot of, courses and volunteer work and information gathered. And then of course you've got big cases, like very complicated cases that
The
of
sex
course are going to
assault
take
cases,
longer.
for example,
Yeah,
with, yeah,
exactly. Or complicated, fraud cases, things like that sometimes take a bit longer, but these are all treated the same. And what that results in is not a motivation to get things done properly. It's just a motivation to move things along or to have accused people to move things along or to take the steps that are necessary, waive their constitutional rights to absolve the court and the government of responsibility. Because at the end of the day, the person who wants delay, least of all, is the accused in custody.
exactly.
They're begging us for a trial
Yeah,
because governments don't properly fund humane conditions in jail. And so they're the ones that want to move things along the fastest. And at every step, they're either asked to waive those rights or roadblocks and bureaucratic impediments are put into place because no one is actually interested in timely justice or justice at all for those people. They just want to be able to go back to their working groups and their committees, and write their discussion papers and check off the boxes on the information, so that they're not the one entering a stay, or they're not the prosecutor who sees the charges go away because the system took too long.
Yes, and that's the thing. That's exactly it. It just feels like they're weaponizing 11B against the accused. I mean, it is a right that exists to protect the accused's right to a trial within a reasonable time. But then it seems like by forcing them to waive 11B, sometimes when, like sometimes the defense is asking for more time because they're waiting for important disclosure. And we see that in important cases sometimes an important piece of disclosure will take some time to arrive, and we're not prepared to set a trial date before we receive that critical information because it will have an impact on how the case is going to proceed. And then it's like, well, are you going to waive 11B? Or, but it is frustrating because it shouldn't be this way. I mean, at the end of the day, 11B is here to protect the accused, not the crown and the courts. So, I mean,
Yeah,
when,
and I mean, like, I'm an equal opportunist critic of things. There are certainly some defense counsel who drag their feet and aren't organized and, want to have everything perfect before they secure a date. Yes, there's some important disclosure outstanding, but, set 3 days for trial and get it done. Um, and, there's, given the delays we have until trial, there's time to work out that stuff. So certainly there is problems on the defense side as well. But when you actually look at the causes of delay, it ain't us. It's not
Mhm.
defense counsel. Mostly, it's an overcapacity issue. I mean, we do have enough crowns. There's certainly always hiring crowns. There's always millions of dollars announced for new crown initiatives and whatever sort of pet project or moral panic is going on at the time. But forms and dragging defense lawyers to court and having extra court appearances and having judges take away trial time that they could actually be hearing trials to micromanage people's schedules is sort of the worst way to combat delay. Bureaucracy has really never made anything faster. Forms, no matter what color the form or if it's a duplicate or triplicate, those never make things faster. It just creates more work. And when we're focusing on sort of the symptoms of the problems, which the symptom is delay, right? When we're focusing on that, we're not actually tackling the causes of delay. And that's what we're not talking about. Why we're using the criminal justice system to deal with mental health, to deal with addiction issues. Why are we criminalizing poverty? Why do hearings and trials take so long? If you get an hour to argue a very complicated case at the Supreme Court, why in God's name is a two witness trial taking 3 days, right? We need to sort of look at how we use the criminal justice system, what's in the criminal justice system, how the crowns use their discretion, because we know when we schedule a trial date, and to avoid 11B issues, to avoid stays. In Ottawa, we're seeing 3 or 4 trials scheduled for the same court time, and we're all real good, but we can only do one trial at a time. And so we get there at that trial date, we're fourth in line, and the Crown, then offers a peace bond or withdraws the charges or agrees to a reasonable resolution,
Yeah.
one that Lens had proposed months and months and months before.
Yeah.
And so those are all resources that are being wasted playing this shell game. So we need to stop, playing that shell game, and we need to actually do the hard work. It should be easy to schedule a trial. That shouldn't take judicial intervention, right? That's like a Google calendar that we can do. We all do this in our personal lives when we're organizing like dinner parties, right? You've
Yeah.
got like 5 friends. They're all doing different jobs at different times. They all have different schedules, and somehow we're able, without a judge overseeing things, to
Mhm.
arrange a mutual date for our party, right? That should be the easy part. And then we can move on to the hard part, being like, why the hell do we have so many people in jail? Why do we think that a court process is going to cure an addiction issue? And why do we have someone who is impoverished and stole some food from a evil corporate grocery store who wasn't prosecuted for its frauds? Why is he in court for a shoplifting when we could actually be using that time in better ways, you know? And so
On
that's
more
what makes it
serious,
so frustrating.
yeah, on more serious cases, like on the murder cases, drug trafficking cases, or to some extent, the real serious sex assault cases, because not every sex assault case is a serious case as well. Some of them, just like domestics, there are allegations. There is, I mean, that become more clear at the trial, but sometimes some of them can be resolved, and the parties do want to resolve them, actually. But it takes me to a point that you raised that we see a lot. It's also, does every case have to be prosecuted? Because, as you mentioned, the crowns have discretion, and there are other ways that we can deal with cases without going through the criminal justice system. Or even like there's collaborative justice programs, there's diversion, and it doesn't seem like we use these resources enough, and that there seems to be like always this willingness to know, well, then if we don't agree on this resolution, and the crowns sometimes, especially in Ottawa, they offer a very harsh or unreasonable sometimes offers, so the accused don't want to accept this offer, so then it's either that or trial, when there are other options as well. But how do we get to using these other alternatives instead of always relying on the criminal justice system?
Yeah, I mean, it's always easier for a crown to just set a trial date, right?
Hmm.
If they're not doing that trial, they'll be doing this trial. So, you know, it's no skin off their back to just set a trial date. And I mean, we have seen sort of a push for sort of these alternative measures.
Yeah.
You know, we have Ben Perrin, Stephen Harper's, you know, former justice advisor, a leader in the minimum sentence, Stephen Harper's sort of justice agenda that we saw actually look at the evidence. And when Ben looked at the evidence, took a step back and looked at the results that he wants to achieve and the ways to achieve sort of that result, which is justice. That's what the justice system is set up for. He, you know, wrote an amazing book that talked about, you know, court is not the way that we find justice in a lot of
Yeah.
cases. It's not
Yeah.
through punitive minimum sentences. It's through collaborative justice. It's through funding of social programs. It's trying to keep people out of court in
Hmm.
the first place. And, you know, I'll remind people, I'm not speaking about crowns individually here, because I know many crowns are of a similar mind. And I've had good success with certain crowns when it comes to diversion, even for serious cases like sexual assault.
Yeah.
But as a system, our prosecutors, the Crown Attorney, our Attorney General, Doug Downey, are cowards. They don't want to be the one to make a decision. They will defer to, they will take their marching orders from complainants when those complainants want to go to court, and they will ignore those same complainants when the complainants want a resolution. Crown attorneys have been reprimanded and subject to discipline because they've referred things to collaborative justice and cases to collaborative justice. And we know that everyone is happier when you go through that sort of alternative process.
Yeah.
And so it's a real cowardice. It's a cowardice to say, I'm not prosecuting, you know, a theft under from Loblaws. It's the same way that there's a cowardice to not prosecute Loblaws when they engage in large corporate fraud. And so, you know, it's that sort of culture that needs to change.
Hmm.
Just because someone's charged and the matter is diverted and everyone's happy at the end, it's not a loss for the crown. That's a win for the crown. It keeps the matter out of court. Everyone's happy. Justice is done. You can use those resources on someone somewhere else. But it seems like no one wants to make the hard call to say no, this it's not worthy of our time. The hard call to make a reasonable resolution offer well in advance of trial, as opposed to being forced to do it. Well, you have you know, an 11B gun to your head because the court is triple booked. And so, I mean, like, I think we need to encourage crowns to not only work collaboratively, but, you know, understand that when you use your discretion, sometimes mistakes will be made. you might divert a charge and that person may commit another offense. But you shouldn't let that necessarily drive you. No Crown's ever got in trouble for saying, I'm not resolving this. I'm taking an unreasonable position. Let a judge decide. But lots of Crowns have gotten in trouble for coming up with creative, just, and reasonable solutions. And I think that's what we need to encourage more. It's really cowardice, I think, that's holding us back from having really meaningful criminal justice reform. Cowardice and a lack of principle and intellect by, Doug Downey, Doug Ford, and, our political overlords.
Yes. And I also wanted to ask you, Michael, how much do you think that Jordan itself is a problem?
I mean, I think that if we want to sit down and we want to look at how long things should take, that's a good thing. Like we know that, the criminal justice system isn't like a fine wine, right? Like things don't get better with age. In fact, for the defense, age is our friend, right? Witnesses disappear, witnesses forget things, people move, like people's motivations changes. Like delay is sort of good for us, but we're the ones who are trying to push for quick trials because,
Our
having a criminal
clients. Yeah.
charge, exactly, it can
Yeah.
destroy your life.
Yeah.
And I mean, not to say that complainants don't want justice too. Like, of course, like complainants want quick trials. You don't, if you're the victim of a crime, you don't want to wait 18 months and thinking about, going to court and what happened to you. You want some resolution. And, witnesses and evidence, it's better when it's fresh. So
Yeah.
there should be a motivation to move things forward. What Jordan does, I mean, like Moldaver pulled a bunch of numbers from his hat because he was frustrated in one of the most unprincipled ways possible. We didn't have people sitting down and talking about how to make our justice system faster or what would be reasonable. And I mean, you can look at it, just the examples that are there to illustrate sort of the absurdity of the Jordan decision. Whether you're a youth or an adult, if you're in the Ontario Court of Justice, 18 months is appropriate. That makes no sense.
Yeah.
Youth matters should be prioritized. They're young people. Like a year and a half could be like,
An
an eighth.
eternity for for
Exactly. Like when you think about where you were at the beginning of grade 9 to the end of grade 10, right? Like, you get your driver's license, you get a job, you get a girlfriend, all of these things, right? And we're saying that the Jordan deadline is the same for youths. Or if I appear in court on the first appearance, I waive arraignment, I consent to committal, and I go up to the Superior Court, that's a 30-month time limit. Why? I understand if you have a prelim in the Ontario Court of Justice before you go upstairs to the Superior Court, of course that's going to take longer and there should be time built in for that. Um, But if you just go up to the Superior Court right away, why does a year and a half get added to how long a trial should reasonably take? Is the Superior Court so delicate that they couldn't complete a matter faster? So when you look at sort of those like incongruities, a theft undercharge and a, week-long sex assault charge, those both, the time limit is 18 months. That's
Yeah,
ridiculous.
exactly. That's the thing. And in addition to that, Jordan came out before the pandemic. It was in 2016. But after the pandemic, it just feels like we're still dealing that backlog of cases. And we still have a few decisions that are left that are from COVID. And I find like since COVID, there has been even more delay just because there was a kind of delay that happened there. There was a time period where there weren't really many cases that were going on. The courts were almost fully closed at the time, and we're still dealing with that. And I just find like these principles that were enunciated in Jordan before COVID are a bit like it just feels there's a bit of a disconnect now because there's a lot more pressure. We have a lot more in the system than we did before. And having to deal with that within these time frames is becoming a lot of pressure for everyone, including Crowns. I mean, even Crowns are burnt out. It's not just a defense problem. I think everybody is feeling tired from the amount of cases. And these deadlines that we have are putting more pressure. So what is your take on that?
Yeah, I think so. I mean, I do think that that the court was right in Jordan to talk about sort of a culture of complacency, right?
Hmm.
I mean, we did have the Court of Appeal call Ottawa's current head Crown attorney the poster boy for delay. So certainly it can come from all sides, that sort of culture of complacency. It's, you know, a lot of lawyers use the remand system as, their calendar and tickler system, right? You can, if you hustle, get things done quickly, but to get things done quickly, it takes time and attention. And when we have a justice system that is used in the way that it does, meaning that most of the accused before the court are impoverished, racialized, marginalized, suffering from addiction, mental health issue, um, unhoused people, um, that takes a lot of work. And when you have legal aid being slashed by the Ford government,
Yeah.
unable to help more people, we have more self-represented people before the courts and self-represented people. I mean, you can times by 10. However many resources it takes with a lawyer, it's 10 times as much for a
Yeah.
self-represented person. And so when you have the court full of high needs individuals who have been, failed by governments who aren't providing adequate, social safety nets and social programming, when they're not being assisted by legal aid, even when they're living in poverty because of government cuts, when people are in horrendous conditions at jail that fall below, sort of any what we would expect to see in any sort of country with any humanity, just the most depraved and terrible conditions, and a criminal justice system that, is bloated and
Mhm.
overworked. We're all overworked. You can see it on the
Yeah.
judges' faces.
Yeah.
You can see it on the crowns. You can see the police officers. And then when you have defense counsel who are being asked to do more when it's our job. I mean, when you look at the process it takes to get to a trial, um, the accused is charged and has a first court date. Defense needs to write for disclosure. Defense needs to follow up for the disclosure. Defense needs to write again when the disclosure is incomplete. Then we need to have a meeting with the Crown to chat with them. Defense needs to make the call to set up the meeting. Defense needs to call in. God forbid we're 5 minutes late or miss a phone call. Crown ain't ever going to call you. Then we need a judicial pretrial. Okay, well, in many jurisdictions, the defense needs to schedule that. We then attend the pretrial and we want to set a trial date. Well, the defense needs to fill out a trial setting form so that we can get a trial setting meeting, so that we can get trial dates, so that we can set them when we go to court the next time. This is sort of the most bureaucratic, crazy system. And you've noticed it's defense needs to write, defense needs to
Yeah.
fill out, defense needs to attend. And by the way, defense is the one without a salary or a
Yeah.
pension helping a client on legal aid where you get a handful of hours that we
And
all
those are
exceed
things we
anyway.
don't get paid for on legal aid.
No, we
So,
do so much we don't get paid for. I guarantee you, ask a Crown to do something they don't get paid for, they're not going to do it. And we don't have pensions, we don't have support. We're largely sole practitioners. And because the Crown attorney's offices across this province have been poaching the defense bar because we've been so burnt out, like during the pandemic, it's us who didn't have a salary. It's
yeah.
us when trials weren't running that weren't making any money. I think the crowns were still getting paid. I think the
Yeah.
judges were doing quite fine.
Yeah.
And so tons of defense lawyers left. So we lose a ton of institutional knowledge. We lose a ton of sort of younger lawyers who sometimes are very eager to do some of those more low level cases. It's all falling. Our shoulders are less broad than they were before. We have less help than ever. We're required to do more than ever before. And our clients are in such a worse place. I think that's where the pandemic has hurt us the most. I
Yeah.
think we've cleared the backlog of pandemic cases. But when you look at the clients with just addiction issues, marginalization, poverty, you know, we're being asked to do more to help them, and we will, and we do. But we get no assistance, and we're expected to do most of the lifting. And so that's why defense lawyers are burnt out because we don't have support, we don't have money, we don't have funding, we don't have anything except a bunch of clients who are in need and drowning and clinging to us for support. And they're bringing everyone down with them, right? Like that's why we can't swim.
Yeah.
And so that's a large problem for the delay as well.
And so, what are your suggestions for if we want to add some optimism here? Because I know we're talking about all the problems that we have, and those are real problems. I mean, I think every defense lawyer who will be watching this is going to feel this frustration because we deal with this on a daily basis. But if we wanted to offer some suggestions for change, what are your ideas on some changes, Michael?
Well, look, no one defense lawyer is going to be able, no one lawyer, no one person is going to be able to change a system that is self-interested and an insatiable beast, right?
Hmm.
Money's not necessarily the answer.
Yeah, I
The
agree.
criminal justice system is fucking insatiable. It will devour every penny,
Yeah.
every minute, every hour you give it. It will use it all in likely the least efficient way.
Yeah, I
So, I mean,
agree.
I think the first thing that defense lawyers and all lawyers need to do is freaking speak out.
Hmm.
Like, I mean, you're doing it, Maya. I write about it. But the number of defense lawyers who complain under their breath and then are utterly silent. We should have lawyers writing for every publication. Hey, it's more work, right? But stay up a couple hours later, write for every publication, talk about this, publicize it, because we need to put some pressure on sort of the political apparatus to get things done because the solutions, aren't really easy. Um, our justice system is over capacity, which means we need to make sure that we divert or decriminalize every single minor offense. If the offense has the word under in it, mischief under, theft under, fraud under, why is it in the criminal justice system?
Yeah, I agree.
We need, even for serious offenses. I mean, I have had a couple of sex assault trials where the accused and the complainant both want to engage in an alternative sort of dispute resolution, right? They want to do collaborative justice.
Yeah,
The complainant wants to do
yeah.
it.
We see
I
that in
mean,
domestic violence cases and a lot of times because they're families, right? They're families. They don't want the family to be, because the criminal justice system, unfortunately, once it intervenes in a family unit, it ruins it, sadly, because there are conditions. They can't communicate, they can't talk. And if they have kids, it's difficult. And so sometimes, and in many of these cases, both parties want to avoid a trial.
exactly. So if we can get the smaller stuff out of the system,
Yeah.
right? And if we can get the system, if we can get social supports and other ways to deal with poverty and mental health and addiction, because that certainly is not being fixed in the criminal justice system, great. And for these longer trials, if you can avoid like a week-long sex assault trial because all of the parties, and you have to be careful. Like there is, sometimes people who are victimized, may, not make the right choices. We don't want to be paternalistic or infantilize anyone, but certainly, there have been lots of cases where Crowns have exercised discretion and there's been a tragedy after, right? That's why they're so fearful of using their discretion now. No one wants to be on the receiving end or a witness at an inquiry after something terrible happens. But there are many appropriate cases that we don't even look at sort of alternatives for. If we can, so I've had two sex assault cases go through a collaborative justice process, and it was a long process. It was a hard process, and everyone, the complainant and my client, came out happier and better served because of that process. But I've also had cases where I had a case where um, me, the Crown, the complainant, the accused, and the investigating officer all wanted in the middle of a trial, a 2 week trial. And it wasn't going well for the Crown. But everyone said, can we look at some sort of alternative process? The
Hmm.
complainant was like, I want to do collaborative justice. I want a peace bond. I want these protective things. I don't want the trial anymore. And so the Crown went up to get approval for what would have been a very good process. And not only was approval not granted, but the head Crown attorney came and sat in the back of the courtroom to make sure that they
It was
continued with
proceeding.
the that it proceeded. And so we had a Crown prosecuting, and then they had Crown attorneys sitting in
Yeah.
the back of the court for a couple days, making sure that their orders were carried out. And so, if we can get cases like that where there can be an agreement, right? There can't always be, but where there can be, if we can get them out, then it's really a capacity issue. And then we can start playing around the margins, right? Then we can say, like, hey, is it better to have a pink form or a yellow form? Is one of them going to make things go faster? Should we have a trial setting meeting that's in court or on Zoom? Should we require judicial pre-trials for cases that take 1 day, or should we save them for cases that are going to take more than 2 days? Then we can try all that stuff. But until we deal with the big stuff, you know, all of that stuff is just moving around deck chairs. Well, the ship, and everyone in court will agree with this, while the ship is sinking.
And do you feel that sometimes again, we're not talking about anyone in particular here, but sometimes there's this feeling that I get, I don't know if you have this feeling, that some crowns have this winning mentality that the crowns shouldn't usually have. Like crowns don't win, don't lose. They should just do whatever is will allow us to get to justice. But sometimes I feel with some crowns that it's really personal. They do want to get a conviction. They do want to see this guy in jail when it's the wrong focus. I feel like,
Yeah, I mean, like, I understand that. If I was a crown, and I truly believe that someone was a violent recidivist who deserved to be in jail, and certainly we send too many people to jail as it is. But if I believe someone was a menace and a danger, like, yes, I would want to prove my case and put them in jail. I mean, I do think though that cultures at Crown's offices, and I've been in Ottawa for 20 years, so I've
mhm,
seen a number of different Crown attorneys in charge. And certainly, like, and I've practiced in places like Pembroke,
mhm,
um, which, I think has done a 180 in the last number of years because of new leadership, right?
yeah.
Same with Brockville. If you want to look at places where there are fewer delays, where things work better, look who's in charge, both like on the bench and in the Crown's office. And, I think that you can see a direct correlation there. Reasonableness, trickle down economics is a myth, but trickle down reasonableness is something that actually exists, right? And so, I mean, we have to look at the leadership and the priorities of the leadership. I remember there is a story that some people may think is apocryphal, where a former Crown attorney in Ottawa was giving a lecture to an Ottawa University law school class. And someone put up their hand and they said, Madam Crown, like, there's lines that we shouldn't cross. And, like, how do you know when you're a crown? You've got all this discretion, you've got your policy manuals and stuff, but where do you know where the line is? Like, how far should you go? And the answer was, if you can't look over your shoulder and see the line, you haven't gone far enough.
Mhm,
And it's sort of that type of mentality that can really infect crowns offices and make
mhm.
crowns fearful to make the right choice, make crowns less reasonable, and set up a really adversarial relationship. And we are in an adversarial system. Um, and, there's limits to everything. There's going to be things that we can't agree on, but when you have crowns asking, I had a crown recently take a position of 30 days in jail for a theft under.
Yeah.
Um, and the guy was like literally stealing food to eat. And I'm like, what's it going to do? Right. And the sort of permission structure to be that unreasonable comes from somewhere. And you either need to have really principled crowns, or you need to have good systems. And I think it like all starts at the top. Right now, we have an attorney general who is, like, I'll be frank, not smart, not nuanced, isn't interested really in justice, and is, a tough on crime politician who is used as the criminal justice system like a political wedge, right? Doug Downey is exactly the wrong person to be in charge of that, and that trickles down. So, what we need to do is we need to look for political change, right? And that ain't going to come from a liberal government that we've had federally. hasn't nothing's changed. It certainly isn't going to come from years of successive liberal and conservative governments that we've had here in Ontario. Things have only gotten worse. And so, if this really is a passionate issue, you've got to look at your politics. You've got to look at the laws, and we've got to like start from the ground up. And that's putting the right people in the right positions, and putting the pressure on decision makers to make sure the right people are in the right positions.
And to add on that, I find sometimes there's also a bit of a disconnect from reality because when you talk about these cases where people are stealing for food, and this is also a reflection of the life we're living in right now where everything is expensive. A lot of people can't afford to buy basic food, and it just needs some common sense, like for crowns or people who are making decisions to just be connected to reality and see we're living in a world now where everything is expensive. Some people, unfortunately, can't afford to buy just bread and cheese. Just that is super expensive. And
Yeah. And I mean, like, that's what's so odious about, the current government in Ontario, right?
mhm,
This is a government who is doing their best to politicize and break a very good judicial appointment process. And it's a government that has appointed like 80% crowns, more than 80% crowns to the
yeah,
bench. And some of my favorite judges are former crowns. Like some of the best judges are former crowns. Some of my least favorite judges are former defense lawyers. It doesn't necessarily it doesn't necessarily mean because you're a crown or a defense that you're going to decide one way or the other. And there's lots of crowns who are super progressive, who volunteer in their communities, who understand how tough things are for everyone. But what I can guarantee you is this: is no crown attorney, has sat down in the same room with, the clients that we deal with,
yeah,
right?
exactly.
Like spent time with someone who is coming in off the street, spend time with someone who has just resuscitated the day before, spend time with someone, and really get to know someone, because it's
Yeah,
our job to get to know those people, right?
exactly.
To live in their shoes, to find out what they're going through, and to advocate for them. And you can be the most plugged in, community oriented, open minded, compassionate crown, and you just don't have that same level of connection. And so, when we do things like appoint 80% of crowns, we lose that sort of diversity
Yeah,
of sort of experience
yeah,
on the bench, right? And that makes it hard to deal with, that makes it hard when you don't have that experience to deal with self-represented accused, to think of efficient and fair ways to navigate the system. And so it's every single choice from, messing around with the judicial appointment process, not appointing defense counsel based on some like crazy ideological position, right? Um, you know, from that to the types of forums and working groups and committees that the bureaucracy sort of defaults to. It's all of these things and in between, including the very foundational laws that we operate under. Everything is responsible for delay, and none of it is getting better.
yeah. Well, I mean, if we want to end this though on a positive and optimistic note, at least hopefully, one good thing that you did mention is to encourage people to speak up and to talk about these issues. Because if we don't complain, or if we don't want to use the word complain, but if we don't talk about that, nobody will really feel the frustration. So I think that this is why the article that you wrote was very popular, and a lot of people were retweeting it or talking about it, is because it does express the frustration that we're seeing and we're dealing with. And so if we talk about all these problems, the frustrations that we see, then maybe that will lead to some change. I'm hopeful that there will be change. I don't know if you're optimistic. I like to be optimistic, Michael, and I like to believe that we can do something, even if it's a tiny step.
Yeah, I mean, I think that these things can be changed. I would
Mhm.
just beg people, beg defense lawyers, put aside your judicial aspirations. You don't want to be a
Yeah.
judge on the Ontario Court of Justice right now anyway. Criticize the government. Don't worry about how it's going to look on you. I've been critical of judges. Like, be an advocate for the system. If you believe in this system, and certainly like our justice system, I do believe it can do great things. And I certainly think that it is a better way to mediate and resolve disputes, even with all of its problems, right? Than the alternatives. Um, and so if you believe in the system and if you believe in justice, then like get off your ass and advocate for it and don't worry about fear or favor or who you're going to piss off at doing it. Um, it's worked out okay for me.
I totally agree. And I like this attitude. And I really strongly encourage everyone not to be afraid. And this is what our job is, right? Like we have to be fearless. And if something is right or wrong, like it's our job to point it and to show what's right and what's wrong. And as defense lawyers, we shouldn't be afraid of telling the truth. So I really hope that people will follow this advice and will find like we'll follow your example and we'll have the strength to talk about things that are wrong in the system because otherwise nothing is going to change.
Exactly.
Thank you so much, Michael. It was so nice talking to you. I mean, just like reading your articles, it's also nice to hear from you directly and to hear what you have to say and to get to know more about your thought process. So thank you for your time today.
No worries. Anytime, man.
Thank you.